In the complex litigation system, disputes over electronic evidence are considered especially heinous. These disputes are resolved by two separate yet equally important groups: the technologists who investigate the data and the attorneys who argue the merits in court. In electronic discovery, the dedicated consultants who analyze and investigate the data are an elite team known as the project advisors. These are their stories.
Okay. Hey everybody, and welcome to our second episode, excuse me, of the Law and Order Discovery Dispute Unit, Fighting Tooth and Clawback. Our parties today are Lockhart, Crown and Dental Company versus STEM Dental Consulting and Innovation. My name is Amanda Cook. I'm the Senior Project Advisor with Acorn Legal Solutions, and it is my privilege to play the role of judge today. Joining me today are my esteemed colleagues, Doug Matthews and Jeff Hudson. Doug is a partner at Voorhees and a member of their litigation group. His practice focuses on electronic discovery matters, and he's the head of the firm's e-discovery practice group. Doug has represented many businesses in the management and discovery of ESI. He'll be representing the plaintiff, Lockhart, Crown and Dental Company. Jeff is our Director of Professional Services at Acorn Legal Solutions. He's an experienced complex litigation attorney, e-discovery project manager, and technology leader who excels in the development and implementation of practical and manageable solutions. Jeff will be representing the defendant, STEM Dental Consulting and Innovation. Okay, we're gonna go ahead and get started. Let me take a sip of water here. I wanted to give you a quick summary of the facts today in case you haven't had a chance to look at the document that I sent over earlier. As I mentioned, the plaintiff is Lockhart, Crown and Dental Company, and the defendant is STEM Dental Consulting and Innovation. STEM Dental was founded by Jonah Stem. As a trained dentist, innovator, and entrepreneur, Mr. Stem worked at Lockhart for 10 years and led the innovation and launch of several successful high-tech dental products. When he was hired, he entered into an employment agreement that included a non-compete clause and an intellectual property agreement that his work would remain the property of Lockhart. After about 10 years, Mr. Stem resigned and he started his own company, STEM Dental, which is a research and development company. As a result of this, Lockhart filed suit alleging misappropriation of trade secrets and intellectual property. At the outset of the litigation, the parties agreed to a protective order that provided the maximum protections under Rule 502D for privilege and clawbacks. During the course of discovery, Lockhart produced 7 documents and then clawed them back pursuant to the 502D provisions. Lockhart also attempted to claw back an additional 700 documents under the same provision. STEM has argued against the clawback of these documents. While in the midst of this discovery dispute, Lockhart has reproduced the same contested 700 documents as part of a supplemental production and is again seeking the same Rule 502D protections. It's come to the attention of the court that Lockhart did not conduct any comprehensive or pre-production privilege review. Rather, they used electronic privilege search terms to exclude, and then they produced. STEM disputes the clawback of the 7 documents and the pending clawback of the additional 700. They argue that the screening methodology is improper and unfairly places a burden on the court to decide these challenges. They also argue that future productions should be subject to the protections under Rule 502B rather than 502D. So I'd like to move on to the issues. And the issues to be decided today are: number 1, whether Lockhart should be permitted to claw back previously produced documents now identified as privileged under Rule 502D. Did Lockhart's privilege review take unfair advantage of the maximum protection provisions under 502D? And should the plaintiff adopt other cost-effective screening methods for privilege screening and/or be subject to the provisions of 502B? We're going to first hear from Mr. Hudson on behalf of the defendants. Mr. Hudson, you have about 5 minutes if you would like to get started.
Thank you, Your Honor. First, I'd like to start by stating that when this matter started and discovery started in this matter, both parties knowingly and willfully entered into an agreement pursuant to Rule 502D. With the notion and idea that it would reduce the burden and reduce the cost associated with reviewing for privilege and allow for callback in the event of an inadvertent production of privilege to allow, as was intended with the introduction of the rules in 2008, for the quick peek without a full privilege review cost to produce the documents. However, what we've ended up with here has been a disregard for the true intent of the rules, the true intent of the agreement, and has ultimately resulted in a data dump where the burden of determining what is actually privileged has fallen on us as the receiving party, and ultimately here up on the court, now that we've had multiple productions made with multiple issues of privileged documents being included. This is further exacerbated by the review protocol that the plaintiffs have chosen to implement or not use by merely using a search string or a series of search terms to only to identify documents that may be potentially privileged. And we feel that that with the 7 documents that were originally produced, that there was indeed insufficient review that constitute a waiver of the privilege of those records. And that insufficient review was further shown with the production of the 700 supplement documents. And that further shows that something needs to be done about this process and about the relying or over-reliance on the agreed upon 502D provision. Because while we were arguing initially about the 7 documents, the 700 documents were produced not once, but twice. And we feel that now we're not only taking time and resources away from the parties, but also from the court, when this time would be better spent and should be on the producing party, the plaintiff here, to ensure that they are properly screening documents prior to production. And we do not feel that the current review process is sufficient. We feel that they have taken an overbroad and taken an unfair advantage of the provision, the callback provision in 502D. So we ask that the court do 3 things. One, identify the previously produced 7 documents that are currently pending a callback to have indeed been waived of privilege due to the insufficient review. That the 700 documents that have now been improperly produced twice to us also be subject to a waiver of privilege and not be subject to a callback. And then third and finally, on a going forward basis, we feel that obviously the 502D standard has been insufficient for the plaintiff in reviewing and production in this matter. And we feel that a standard more in line with the requirements of Rule 502B are in line, where we withdraw the general overarching clawback and require that the plaintiffs show that any production made was inadvertent, that they took reasonable steps to prevent that. In the case of the 707 documents previously produced here, we would argue that they have not taken reasonable steps to prevent, and that they take prompt steps to rectify any error. So basically eliminating the clawback without some further proof and requirements placed upon the plaintiff in order to not waive privilege on a going forward basis. And with that, I will yield the remainder of my time to Mr. Matthews.
Mr. Hudson. Mr. Matthews, please proceed.
Thank you, Your Honor. Your Honor, the issues in this case are extremely straightforward. The parties negotiated a Rule 502D order that called for having the maximum protection for allowing a clawback of documents. That order should simply, and that agreement was turned into an order which you have entered. That order should just be enforced using those maximum protection standards. The defendant now wants to talk about the level of care that we've taken. We think we took a very adequate level of care under the circumstances. However, that is totally irrelevant because we are talking about a maximum protection 502D order. Your Honor, there's a clear distinction between Rule 502B, where there's no order, and a 502D court order. The 502B provisions do expressly require that a clawback can only occur where the production was, one, inadvertent, two, that reasonable steps were taken to guard against the production of privileged documents, and three, that you promptly attempt to rectify once you discover that a privileged document has been produced. In contrast, the 502D provision simply says that a court can order that the protection is not waived if it's disclosed. With none of those 502B requirements, including any requirement that you take reasonable steps to ensure that production is not, that privileged documents are not produced. If the defendant wanted that in there, they could have negotiated that at the beginning. They did not, and so we should simply enforce the order as it's written. That interpretation is really recognized by the advisory committee notes to Rule 502. They recognize that with the volume of ESI, that old requirements that you do a document by document review were simply too expensive, too prohibitive, and too disproportionate in many circumstances, and the parties should have the ability to negotiate a different structure for clawbacks that allowed to be very predictable. And that predictability allows you then to have a plan that will prevent having to expend prohibitive amounts of money. And indeed, those advisory committee notes expressly allow or discuss that the rule allows an order adopting a clawback provision in which you do no privilege review at all, called a quick peek agreement. So that is, when you say maximum protections of 502D, what the parties agreed to, that could include no care taken whatsoever. And in this case, we certainly didn't do that. We had a system in process. We tried to use search terms to identify potentially privileged documents. You're going to miss some. And unfortunately, we had some other human error which resulted in the 700 documents being produced again, which is regretful. But again, level of care is not an issue in a maximum protection under Rule 502D. There's a case that was cited, Arconic versus Novellus, where the court has recognized that Rule 502D involves this broad protection, and the parties have a right to negotiate that allocation of risk and cost and how they do a production. So we were entitled to rely on the system that we'd agreed to and the court order. The defendant is also asking that we now set aside that agreement, even if for going forward as a minimum amount, and we also believe that that is not appropriate here. Again, the parties negotiated this, decided to do a maximum protection agreement, and that should remain in place. They talked about how they're claiming some additional burden for identifying privileged documents falling on them. Your Honor, that simply isn't the case. We still have that burden, and that's what happened. Is we noted, oh my gosh, we accidentally produced these privileged documents. We're the one who still had to figure that out and claw them back. There's no added burden on them in doing so. We're the ones who suffer the fact that we did disclose them, and you can't unread what's been read. So there's no more burden to them for us continuing to use this system going forward. We also believe there's no additional judicial resources that are going to be involved here. If the documents had never been produced, they would have been on a privilege log, And if they wanted to challenge the actual privilege, we would be doing that. All you're doing by keeping it with the maximum protection, that's the only issue that's ever going to be litigated, is whether these were in fact privileged documents. If you change the rule to go to a 502B standard, even though no one ever agreed to that before, there would be more judicial resources being expended because we'd be fighting over the process. The most efficient way to do things, Your Honor, is to let the parties live with the agreement they made and enforce this order to the maximum protection, both for the previously produced documents and any document that's uncovered as being privileged later on. Thank you, Your Honor.
Thank you, Mr. Matthews. Okay, well, I am going to issue my ruling. My first ruling as to whether Lockhart is permitted to claw back their previously produced documents is twofold. For the initial 7 documents that were produced and then clawed back under the 502D provisions of the protective order, we're ruling in favor of Lockhart. These have already been clawed back, and the defendants have not articulated a good reason why this inadvertent production constituted a waiver. And you are correct that 502E states that an agreement on the effect of disclosure in a federal proceeding governs, and that's if it's incorporated into a court order. However, I disagree that there was sufficient agreement between the parties, or we wouldn't be here today arguing these issues. The protective agreement does not outline what the parties agree is an inadvertent disclosure, what reasonable steps to safeguard from disclosure should be, or what reasonable steps were taken to rectify those disclosures. And therefore, the court must fill in the gaps. Lockhart was aware that the electronic screening review methodology without comprehensive review was at best flawed, as they've already produced 7 privileged documents. And at that time, they should have put in additional measures to safeguard the privilege of the documents. They did not do so, and instead produced an additional 700 documents based on the same methodology that was previously shown to not work appropriately. Then, while litigating this exact issue, Lockhart reproduced the same 700 privileged documents. It's incumbent on an attorney to zealously guard the attorney-client privilege, or they run the risk of waiver. Lockhart has not demonstrated that they took reasonable steps to safeguard the privilege for the 700 documents, and therefore the court rules that privilege has been waived for those documents. As I previously outlined, the clawback agreement did not sufficiently describe how the parties agreed to take reasonable steps to prevent disclosure. And the court finds that the cursory review of running only search terms and subsequently reproducing privileged data does take advantage of the protections under Rule 502D. If Lockhart does not want future protections to be subject to the provisions of Rule 502B, they must utilize other cost-effective methods to screen for privilege. The court should not have to continually decide if documents are subject to the clawback when there are simpler solutions available. Therefore, the court orders that the Rule 502D protections will apply to future productions so long as Lockhart establishes a more rigorous screening methodology. If the parties come back before the court to litigate this agreement again, we will then apply the provisions of 502B. Okay. And I thank you for your arguments, and we will enter an order to that effect.
Thank you, Your Honor.
Thank you, Your Honor. I want to put you on, we are going to be appealing that order.
Understood. As expected. And so to everyone on the call, we actually did base our facts and our arguments on a few cases we wanted to provide you, and Mr. Matthews cited. If you would like us to send you a copy of these, please let us know. The first case took place in the Western District of Pennsylvania and was a trade secret and misuse of confidential information case. Basically, in that case, the protective agreement provided the maximum protection under 502D, similar to here, where the production of a privilege document, whether inadvertent or not, would not constitute a waiver of privilege or work product. In that case, they had to appoint a special master because the discovery issues became so contested, and they found that the decision by one of the parties to adopt a screening methodology that was just based on electronic term searches rather than comprehensive review did take unfair advantage of Rule 502D protections. They also ruled that in relying entirely on 502D without any review was a completely inefficient use of the court's resources. And they recommended 2 approaches going forward, one of which was they were entitled to 502D protections for the documents already produced, subject to a 502B standard for future document productions. This two-pronged approach would enable the parties to claw back inadvertently produced documents only if they took reasonable steps to prevent disclosure and to rectify the error. The second case was in the Southern District of Ohio. This was a breach of contract case, and amongst many other causes of action. The parties had agreed on how they would produce ESI and included a clawback provision that stated a formal court order was not necessary, and that if somebody accidentally produced a privileged document, they would notify the other side, and then the receiving party would destroy, and it would not operate as a waiver of privilege. This one is a little messier, similar to our case facts. The defendants there produced 43 privileged documents, and only when they were preparing their privilege thought did they realize that those privileged documents had been produced. They requested a clawback, but by the time that the request was received, the plaintiff had already reviewed them and argued they were not inadvertently produced, but rather not thoroughly vetted for privilege and refused to return or destroy them. The court took a look at all the documents and pointed out that at least a third of the documents contained terms as like legal guidance from legal signature blocks identifying people as counsel, and questioned the defendants as to why they didn't recognize the documents as privileged. 6 weeks after they initiated the clawback, the defendants again produced the same 43 privileged documents and blamed it on an error by litigation support staff. This case is really interesting. The court analyzes waiver and privilege and how all the different courts approach these things. And they found that these documents were in fact privileged, but then moved on to whether the privilege was waived by the behavior of the parties. The court found the production of the documents fell under Rule 502E and examined the effect of the clawback agreement permitted by Rule 502E. The defendant argued that the agreement should control, much like Mr. Matthews, and the court noted that there are many different approaches used by the courts, where it's strict, it has to be reckless, or kind of the reasonableness standard under 502B. The court did not think any meaningful review of the documents occurred, and the attorney's behavior was reckless as to protecting that privilege. They used the 502B rules as an analytic framework to analyze the issue, and they decided that the defendants did not take reasonable steps to prevent disclosure and waive the protection of the documents. That one is on appeal, so we'll see what happens. And the Western District case is, I believe, still in the throes of evidentiary discovery. So this is all still sort of shaking out. So we'll see where this ends up. But those are the actual cases we kind of based our thought pattern on. So at this point, we wanted to open it up to see if anyone has any questions or have encountered situations like this, or anything you want to chat about.
Well, while we're waiting, I think it's interesting. My personal opinion is that I think the rule, especially when you read the advisory committee notes, really intended to give the parties that ability to negotiate, and it expressly talks about that ability to do no review whatsoever, a quick peek. And when that's put into an order, then there's no reason why reasonable care should even be in there. I think that the judges don't like that. It's a big change, and I think you get some, all right, we're going to try to rule around that language. And I personally believe that, look, parties should be able to negotiate what they want. But recognizing that courts are skeptical of these things, there are a couple things I think you can do. In reading that Earth case, and again, that case did not involve a 502D order. It was just an agreement, which is why, number one, you should always have it in an order that the court issues, because your arguments are much stronger. But they were really, well, you didn't expressly deny, you didn't expressly in the agreement reject the fact that you wouldn't have to show anything, so I'm going to put that requirement that you still have that reasonable steps in there since you didn't expressly disclaim it. And I think the court even went as far as to say that it wasn't going to rule on whether or not you could even do that, even though the advisory committee notes say that. But what I would recommend, if you want a maximum protection 502D order, don't just say we want the maximum protection is being applied. Put in that there will be no need to show inadvertence, reasonable steps, or prompt rectification, and put that in there very expressly. And if the court adopts that and the other side agrees to it, you should be better off from, the second guessing down the road.
Yeah, I would tend to agree that the two key components of 502D in alignment with the notes are make sure it's an order and then expressly state the things that are included in the maximum protection.
Totally agree.
I think, and I sort of understand the court's hesitance to just say, okay, nothing has to be reviewed, because there's concerns there. You can't unring the bell, right? So.
But usually the harm of that falls on the producing party. I think it's just so different than how judges were brought up with you had to do this.
Right.
That it kind of ignores that, look, the volume is so much, and rather than waste judicial resources arguing about whether what you did was okay, if you agree that you don't have to do it, I'm going to wash my hands of it. I don't have to worry about it. But that doesn't happen all the time.
But then that raises the issue. I think that was in the Earth case where then you raise confusion during depots, like what can people use? When can they use it? Like it can cause a lot of uncertainty for the proceeding in the litigation if you don't know what you are or not allowed to use.
Yeah, how far along in the process can you raise the, oh, I inadvertently produced this privileged document, you can't use it? I mean, I think the judge explicitly stated, we're not going to wait until trial to decide this when we have a witness on the stand. So we have to come up with some type of steps in this process to determine it sooner rather than later, because we don't want to continue down this endless path.
Right.
I think that makes sense to do sort of certainly at the trial. And I think it also makes sense. So let's say that document was used in a deposition and there was testimony about it. And the party obviously I think could raise that right then and refuse to let them answer questions. Then it's just a fight over whether it's privileged. But if you didn't do it, then I don't think you can go unring the bell when you've already had testimony about it. I agree. That would be going way too far.
And
did you guys make a conscious decision to have the plaintiff be the one who was trying to claw back versus the defendant?
it was not necessarily a conscious decision, Aaron.
Okay. I ask because in my line of work, most of the time I'm counseling plaintiffs' class action lawyers not to accept the 502 and 502D and skip and keep the 502B, because they end up being a lot of times the 502D orders are written as carte blanche for the defendants to use that maximum protection, and as a result, they can't actually hold anybody accountable for their process with the millions of documents that they may be producing.
Yeah, I think that's right. If you're not going to be producing that many documents and you want to hold the other side's feet to the fire, I think I would put it slightly differently. I would insist that the 502B standards be built into the 502D order, because the other big difference that an order makes is that it also applies in other litigation, where if you just have an agreement, you've agreed that you're not waiving between the parties, but if somebody else files a lawsuit, they can argue that you waived by doing this. And the 502D order gives you the protection of that non-waiver in those circumstances. But I agree that if you don't care about how hard it's going to be for you to produce documents and make sure you haven't waived, you might as well demand the 502B standard.
That's interesting. Put the B in the D. I like that.
And Aaron, I think you know me well enough to know that that any opportunity for the plaintiffs to call back a document is unique, and having the opportunity to be a part of an argument like that, it was not completely unintentional.
So I don't know if we have any other questions or comments, or if anybody else wants to say anything. We're trying to keep this to a half an hour and it's 2:30, but happy to stay a little later if people want to chat. Let's see if anybody's in the chat group. Nope. Okay. Well, in that case, I want to thank you guys for your time and your participation. I think it was very interesting, and I hope that everybody on the call learned something new or something interesting today. And we really appreciate your attendance, and we hope you guys show up for the next one.